We will start with Dr. Daphna Avnieli. You may not know, but she was raised in Iran and studied the International High School for Children of Diplomats in Tehran. There used to be some good days. She worked as a lawyer at the IDF, then as an independent lawyer, and then at the Attorney's Office at the Ministry of Justice. She was appointed to a judge at the Tel Aviv District Court and heard important financial cases. And Daphna is the head of the Institute of Legal Arts at the Faculty of Law in Tel Aviv University and a valued arbitrator at the IICA. And I would like to, maybe you can tell our distinguished guests from abroad about the Israeli legal system in general and in relevance to arbitration. What is the role of court and how much does Israeli court interfere with the arbitral award?
Thank you, Menashe, and welcome everybody. This is really thrilling to see such a large audience this morning. When we all made our way through the empty streets of Tel Aviv, I was amazed to see how the streets were empty and to find so many old and new friends here together. I have a small anecdote to you before I'll start answering your question, Menashe. Since I was raised in Iran, I can speak Farsi. And I had, when I was a judge, still a presiding judge, I had a case which involved two Parsi families. Now, they never imagined that I could speak Farsi, so they had some small conversation among themselves about the proceeding, about how to go about with the witnesses, about how the judge will never understand what we're talking about. At some stage, I said, I have to interfere, and I have to let you know that I understand every word you're saying, and from now on, we'll stick to Hebrew. So the diversified world we live in is also very much impersonated in Israel, because with the establishment of the State of Israel in 1948, English law and Turkish law, Ottoman law, remained binding in Israel because there was no Israel legal system at the time. And these two systems, the English system and the Ottoman system, remained binding until the Knesset slowly, sometimes quickly, but mostly slowly, enacted new original Israeli laws. So nowadays, we still rely sometimes on English precedents, more than that on American precedents. So we have some remainders of the Ottoman law. We have original Israeli law. And in all this, we are trying also to find our way in the international community of judges and lawyers, and especially arbitrators, which is the topic of our conversation today. Now, I was asked to describe our court system in Israel, and I will do so briefly and tell you that we have in Israel a three-tier system of courts, starting with the magistrate court, which I was appointed to at first, not first to the district court. And I was appointed when I was very young. I was 39 years old then. And I was in the magistrate court for 12 years because before I was nominated to the district court for Tel Aviv. Altogether, I was a judge for 25 years. So the magistrate court deals with cases, civil cases, which monetarily are up to 2.5 million shekels, approximately $700,000. The rate of the dollar is changing every day now in Israel, so it's hard to say. But approximately $700,000. And in cases, criminal cases, where the maximum punishment is 7 years imprisonment. The district court, which is the second tier court, is first of all a court which has the jurisdiction upon matters that the magistrate court is not dealing with. And it is also a court of appeal for magistrate court cases. And it deals with most administrative cases in Israel, which were brought down by law to the district court before they were dealt in the Supreme Court of Israel. Above that, the third tier, we have the Supreme Court. Altogether, we have 14 judges in Israel. 25% of them are women. In the other courts, 51% of the judges are women. We are very proud of this. And we think that a diversified court is really the one that we should aim to. A diversified court meaning from all genders, from all understandings, from all political views. Hopefully this will come true in the future. We also have tribunals, religious tribunals in Israel, Jewish, Muslim, Jews, and Christian tribunals with exclusive jurisdiction over things of personal status. For example, divorce in Israel is dominated solely by the rabbinical tribunal, and if you want to get a divorce in Israel, you have to go through the rabbinical court in Israel. The appointment of judges in Israel is a special procedure here. In order to apply or to be eligible to become a judge, you have to have at least 5 years experience as a lawyer, which is not too much. And then you are appointed by a committee which comprises of 9 members, 3 Supreme Court judges, one of them the President of the Supreme Court, 2 government ministers, one of them is the Minister of Justice, 2 members of the Knesset, one from the opposition and one from not from the opposition, and 2 representatives of the Israeli Bar Association. This is true today. It may not be true next week. We don't know. But still, we think, as judges and as lawyers, that this kind of committee comprised of differentiated members from all sectors which are connected to the judicial law has the best skills, information, and qualities to appoint judges. And it may be diversified a little bit, but still we believe firmly that such a committee is the best solution in Israel, which is a country of diversified population. Today, nowadays, we have 807 judges altogether in Israel. We have more than 72,000 lawyers, about 55,000 of them are active lawyers, producing law cases, presenting claims and representing people in the courts. So if you make the mathematics, you may understand that there is an enormous workload on the judges, meaning that altogether in the judicial system, 807 judges have to deal with all the civil and criminal cases in Israel. This is one of the reasons, not the only reason, why many lawyers now choose to divert to arbitration. Now we are really promoting this attitude. We are trying to introduce arbitration in many cases. As a judge, I can tell you that many times I suggested to people that they should consider the possibility of going to an arbitration proceedings or mediation proceedings, which are also quite popular in Israel, but not popular enough. If we're speaking about arbitration in Israel, the arbitration process is governed by the arbitration law from 1968. It was already mentioned by Julian. It has to be reenacted, it has to be modernized, but this is the arbitration law that we have now in Israel still. And this really abides in arbitration proceedings in Israel, unless the parties decide that the law is not binding in the arbitration proceedings and they choose to conduct the arbitration differently. One point that I should mention is the question of bilateral or parallel proceedings. Suppose there is an arbitration clause or an arbitration agreement between the parties, but one of the parties decides to present the case in the court instead of initiating an arbitration proceedings. According to the arbitration law, the court, in a dispute with an arbitration clause or arbitration agreement, if one of the parties applies for stay of proceedings of the action, the court will usually stay the proceedings. This is the normal proceedings, because the court really respects and wants the parties to abide with the arbitration proceeding agreement. The court, of course, has a discretion not to stay the proceedings, but for special reasons. Sometimes when the arbitration proceedings will not be efficient enough, or if one of the parties expresses any anxiety about the arbitration proceedings. But mostly and usually, the court will stay the proceedings. The court will also stay proceedings if the parties were a party to international convention about international proceedings. This is really very much respected in Israel. Mostly, almost never the court will consider not staying the proceedings unless there are very, very serious reasons not to stay the proceedings. Now, as far as the intervention of the court in proceedings conducted in Israel, arbitral proceedings, according to the law, the court is very cautious in intervening in arbitral proceedings. It will do so in very specific circumstances. For example, when a party is asking for the removal of an arbitrator and the arbitrator refuses to remove or recluse himself. Now, the reasons for removal or inclusion of arbitrators are numerous. I won't go into them, but one of them, or the main one, would be conflict of interests or other reasons that will ensure that the court will consider if such a petition is applied to the court. In addition, the court has auxiliary powers to assist in arbitration matters, and many times arbitrators or the party apply to the court for auxiliary powers. For example, the summoning of witnesses when the witnesses don't abide for the summation issued by the arbitrator, foreclosure of assets, which is in the discretion of the court, temporary restraining orders, and interim relief. As far as the arbitral awards, when you already have achieved, you have completed the process and you have achieved an arbitration award, the court mostly refrains from interfering in arbitral awards, and mainly it will not interfere in the decisions of the arbitration or the proceeding itself. The court will intervene for only 10 set of reasons that are set by law, and this is a closed list of reasons that the court will intervene, mainly relating to the procedure itself. For example, if the award was made by an arbitrator which was not properly appointed, if the arbitrator acted without authority. So you can imagine for very serious reasons the court will intervene, and mostly the court will not. You may ask yourself, what is the case when the arbitrator made an error? An error in applying the law, an error in applying or understanding the witnesses' testimony, such errors. Would that be a reason for the court to intervene? What would you think? Yes or no? Of course not. Of course not. Of course not. This would be a case for a court to intervene only if the parties have agreed that the right to appeal is reserved to the parties after receiving the award. The parties have to agree in advance, in the beginning of the procedures, on the way of and manner of appeal. You can appeal before another arbitrator, or you can appeal to the court by admission of the court. But this also is for limited reasons, and the reason is that the arbitration law in Israel really tries to respect the arbitration proceedings and to encourage the parties to pursue the arbitration proceedings to the end and to receive the award and abide by the award, unless there are very, very serious reasons not to. The appointment of arbitrators in Israel is also interesting because firstly and mostly it's a part of the party's choice. As well as the parties decide to join a contract with an arbitration clause or an arbitration agreement, they can also choose the arbitrator upon their own free will. The arbitrator can be a lawyer, it can be a specialist, for example, an audit, if there's a question of the auditors, or a retired judge. It is quite popular now in Israel to agree that a retired judge will be the arbitrator. I think it's because the parties trust the experience and the long standing years of the judge, and usually in Israel, people know each other. They know the lawyers, they know the judges. They don't need to go to the Google. They have their own personal way of finding out who is the arbitrator and choose the arbitrator which is most suited for their choice. There is also a possibility that the parties will decide or agree that a third party will nominate the arbitrator, such as the president, like Menashe, the president of the Israel Institute for Commercial Arbitration. It's becoming very, very popular to stipulate in the arbitration agreement that the president of the Israel Institute for Commercial Arbitration will be the one who will recommend, maybe not just nominate, but recommend to the parties a number of arbitrators upon their choice so they can decide among them. It's also popular to decide that the head of the Israeli bar will nominate. but it should be a person or an institute that the parties rely on and on their discretion and their advice. The court may also appoint an arbitrator if no agreement has reached whatsoever about the identity or the party that will nominate. Then the court can apply and appoint the arbitrator upon its discretion. I think that the reason that judges are now more popular as arbitrators, and it's becoming a trend in Israel, as far as also arbitration proceedings are becoming a trend in Israel, is because it is sometimes necessary to know how to conduct the proceedings, even if the parties are willing and cooperating in the proceedings themselves. Just a small example, a very lengthy cross-examination during arbitration proceedings will be, sorry, I'm asked to end my discussion, so I will do so in a minute. So the decision of the parties to try and nominate a retired judge is also because they trust that the judge will be more experienced and less intimidated in the proceedings themselves, because the aim finally is to have very effective, small, and quick proceedings of arbitration. I think from my experience as a judge, which I now apply in proceedings where I am an arbitrator, that we should all endorse arbitration proceedings. And I hope these conferences, like the one we have here and the ones you have elsewhere all over the world, will be the new promotion, I think, for arbitration proceedings in Israel and for international proceedings as well. Thank you.
Thank you very much, Daphna. And yes, in the IICA, we receive cases both from courts and from arbitration clauses. And when we get a case or dispute, we recommend, usually we recommend, we don't nominate, we recommend 3 proposed arbitrators. And by the way, most of the cases, as Daphna said, are being appointed by judges. I mean, local disputes are judges are being appointed, as far as our experience. Dr. Gilad Noam, you talk about, Daphna talked about Persian language, and Dr. Gilad Noam is not only has a doctorate in law, he's also a bachelor degree in Arabic and Arabic literature. So you can speak with him freely. And Gilad is the Deputy Attorney General for International Law. He was involved in cases at the International Criminal Court at Hague, in Hague, and was leading negotiations on behalf of the State of Israel in many international discussions and agreements. And as a key person in the Israeli Ministry of Justice, could you share with us some facts and figures regarding the Abraham Accords, your work, and have we achieved our goals up to date?
Thank you very much, Menashe, for the introduction, for the question. It is an honor to be here today as Deputy Attorney General for International Law at the Israeli Ministry of Justice, and to be able to participate in this important event, which brings together both international and local practitioner, judges, academics. It is of particular honor to be here with colleagues from the UAE, from Morocco. I would like to share with you some insights from the Abraham Accords and discuss the role of that my department played in drafting the accords, as well as the role that we, together with other ministries, some of whom are here with us, continue to play with respect to many agreements that have stemmed from the accords. So the Abraham Accords reflect the great potential of peace and cooperation in a region affected by long-standing conflict. This past September marked 2 years since the signing of the historic Abraham Accords between Israel and the United Arab Emirates and Bahrain. Soon after, in October 2020, Sudan signed the Abraham Accords Declaration, followed by Morocco, Israel and the United States, who signed a joint declaration in December 2020. So we are approximately 2 years, a bit more after those events. The accords, besides establishing a new era of peace, diplomatic and economic relations, lay foundations for enduring cooperation between Israel and regional neighbors at all levels of government. If you've had a chance to review the agreements, you will have noticed that the agreement with the UAE, for example, provides that the parties will work to conclude bilateral agreements in over 15 different spheres, thereby unlocking the great potential of both countries and the entire region. The activities covered include finance and investment, water, civil aviation, legal cooperation, science, technology and outer space. Both sides try to anticipate their future needs and provide a foundation that would become the basis for future agreements and cooperations. Today, we can already see that just after 2.5 years, which included the global pandemic, the accords are bearing fruits in the Middle East, and interestingly, even beyond the region, because they have created a dynamic, a momentum of their own that other countries can latch onto. They have reintroduced into the geopolitical space the notion that common economic and strategic interest can open the door to genuine peace. To get a sense of the staggering impact of the Abraham Accords, there are more than 90 different kinds of agreements with the UAE, Morocco, and Bahrain, which include MOUs, declarations, and other commitments which have stemmed from the Abraham Accords in a variety of fields. Some of these instruments are in force and applicable, while others are still in the pipelines. This shows how the Abraham Accords unlocked this untapped potential of economic and strategic interests. Recent years were busy for us at the Ministry of Justice. We provided legal advice with respect to negotiating, drafting, and ratifying many of these agreements. Let me list just a few examples. Just 1 month after the finalization of the accords, it was October 2020, we initiated and finalized negotiations on a bilateral investment treaty, BIT, between Israel and the UAE. Due to the pandemic, for the first time, we negotiated the entire BIT through a video conference. Incredibly, the negotiations lasted just 1 week. I'm not sure if you are aware of negotiations around BITs. They can take many months, sometimes maybe even years. The BIT was signed by the UAE delegation who, due to the pandemic, arrived in Israel but did not leave the Israeli airport, and the signing ceremony was held at the airport itself. In September 2022, just a few months ago, negotiations on a free trade agreement between Israel and Bahrain began. The agreement was led by the Ministry of Economy and included a representative from our department at the Ministry of Justice, as well as the Ministry of Foreign Affairs, the Ministry of Finance, and Ministry of Agriculture. After 2 negotiation rounds, the negotiation is now nearing conclusion. The comprehensive agreement is expected to include issues of standardization, rules of origin, trade levies, government procurement, as well as reciprocal tariff reductions on agriculture and industrial goods. A third example, an inter-ministerial team led by the Ministry of Finance started negotiating BITs with Bahrain and Morocco, and we hope to finalize them in the near future. Another example is another milestone during these 2 years was the finalization of the free trade agreement between Israel and the UAE, which was signed in May 2022 in Dubai. Remarkably, the agreement was signed after only 5 months of negotiations, which for Israel were led by the Ministry of Economy. And despite the short negotiation time, the agreement is a comprehensive one. It includes 18 chapters covering market access, rules of origin, custom procedures and simplification of trade procedures, services, digital trade, government procurement, and a dispute resolution mechanism. The free trade agreement provides that 96% of all goods traded between the countries will be immediately or gradually exempted from customs duties, including in trade relating to food, agriculture, cosmetics, medicine, and many more. The agreement is expected to enter into force in the coming months. One of the unique elements of the free trade agreement, this free trade agreement with the UAE, is the accession article, which allows other countries to accede to the agreement, thereby transforming the bilateral agreement into a potential multilateral agreement with other countries. Did the agreements fulfill their potential? With data, we can look on the data, we can actually track their impact, and here are some examples. We can see that the volume of bilateral trade between Israel and the UAE in comparison to 2020 jumped almost 550% in 2021, and it is expected to keep climbing. In the first half of 2022, for example, bilateral trade reached $1.2 billion, representing a 117% increase compared to the first half of 2021. This is especially remarkable because, as I mentioned, the free trade agreement has not yet entered into force. Once in force, the trade agreement will likely increase trade between the two countries, reaching $10 billion annually over 5 years. These are the expectations. Investments by companies from the UAE in Israel in the first half of 2022 exceeded tens of millions of dollars. In just 1 year after the joint declaration, trade with Morocco increased by almost 90%. Aside from the Abraham Accords and the many agreements stemming from them, our department also provides legal advice with respect to the negotiation of economic agreements with other states around the world. For example, with respect to free trade agreements, we are currently in the midst of negotiations with several countries, an extensive free trade agreement with the UK, and free trade agreements with China and Vietnam. In just 2.5 years, we can see the important impact that the Abraham Accords have had both in the region and beyond. Looking ahead, we expect to see increased collaboration, trade, and investment in the Middle East and Northern Africa region. I hope that there won't be a need for your services on dispute resolution, but I believe that my fellow panelists here will discuss the issue of ADR in the MENA region further. I must apologize, Menashe and my colleagues here. I won't be able to stay for the entire event. Thank you very much for the invitation, for giving me the opportunity. Thank you.
Thank you very much, Gilad, for the fascinating figures and talking about $10 billion trade volume that is going to happen in the next few years, we all hope. There must be some disputes and there must be many, many arbitrations. We're sure about that. My friend, Justice Shamlan, he's the head of Arbitration Division in DIFC courts, and he is a member of the advisory court in DIAC, in the Dubai Arbitration Center, in Saudi Arabia Arbitration Center, Russia, India, and the IICA. And if you may share with us the legal system in Dubai, especially the two jurisdictions, the civil law and the common law that lives together, and if you will have time, but really shortly, about Bahrain and Saudi Arabia and how can it comes together, working together with Israel and in arbitration in general.
Thank you, my friend. First of all, I would like to thank my best friend Menashe and Shai to encourage me to come to the Tel Aviv for the first time. And the third person, I would like to thank my mentor, Professor Lou, as well, to encourage me to come to Tel Aviv. The fourth person is my wife. And the reason why, because not for shopping. Of course, you cannot compare Dubai with somewhere else, but to see the history of the city, and to because she likes history and stuff like that. So unfortunately, she stays in the hotel right now and enjoying the history of the city. Generally speaking, and somehow I said our relationship with the Israeli party also always start on the sky. You know, UAE, Saudi Arabia, now Oman. Then we go to the ground and we sign an MOU and join the Abraham Accords. So some reason for that. But generally speaking, when it comes to Dubai and arbitration practice, civil law, common law, Dubai and UAE, they, there's a lot of arbitration practice long time ago there, but the development started from 2016 when we got arbitration law based on the UNICETRAL, and I wouldn't say 100% based on the UNICETRAL, but it's a good development. So a lot of arbitration taking place in Dubai and Abu Dhabi. But the leadership of the UAE, they decide 2004 to create a financial hub. And the leadership say what is needed to be done. So they said we need to have a new set of laws based on the common law practice. So the leadership then encouraged the advisor, the legal advisor, and the law firms to work together. So the UAE constitution has been amended to adopt the new common law concept. So we have a DIFC, Dubai International Financial Center, and they create a set of law which is based on the common law, international best practice, and they create a common law court, special court based on the common law. And this is something perhaps the Israeli, government can take away with to enhance the reputation of arbitration. Taking the model of Dubai or Singapore, where still you need to have kind of international element to the judiciary. And this is something, whether we like it or no, the international law firm and international business community, they would like to see this sort of specialize in the judiciary wherever they go. Can you imagine the Singaporean judiciary? They're doing very well, but even though they create international commercial court. Dubai did this before. Abu Dhabi, they have the same structure of having a common law court. The Qatar, they have the same. And perhaps Saudi Arabia next. But this is a very important element to build the trust in terms of international litigation, and especially when you have international arbitration. Still, you need to have a special court, kind of understanding the culture of international arbitration. You need to have judges who are very familiar and very friendly to arbitration. And this is something I'm doing now in the IICA court, where we're supporting the arbitration with the anti-suit injunction, and an interim and freezing order to help the arbitration process. So, generally speaking, UAE, like other countries in the Middle East, will follow the civil system. And the Dubai judges or Abu Dhabi judges, or even in Bahrain and Saudi Arabia, they're not that much used to be friendly to arbitration, let's say. But last 10 years, there is a lot of improvement was there, especially in the court where it has a mix of international judges. So we have a DIFC court based on the common law. We have what's called offshore. We have an onshore court in Dubai. Frankly speaking, not just for arbitration. Last year, it was a case filed in the DIFC court involved the Israeli Business Tourism Party, and they opt-in to the IFC court jurisdiction. Unfortunately, the Israeli party, they lost the case, but there's nothing new about that. So it's then another Israeli party, they opt-in again to the DIFC court for, hoping for the best. But the point is now there is already, from the business community from Israel to UAE, so the UAE court or the DIFC court on the radar. And the way they opt into the DIFC court, because we have something called SMEs court, Small Claim Tribunal. It's speaking English A to Z, and you get the order in 3 weeks' time. I think this is the things we need to focus on in this region, how we can help each other from Abraham Accords. Menashe and I, we keep doing this dialogue. We have the first session in Dubai. This is the second session about Abraham Accords arbitration. Maybe next one going to be in Bahrain. We need to support each other in this regard. The Saudi community as well, they are now supporting the arbitration. The Saudi Arbitration Center, they have an office now in Dubai as a branch. Bahrain Chamber of Dispute Resolution, what they call it PCDR, as well, they are very specialized in international arbitration, and they have a special court to do with arbitration. So the summary of my saying is that if you want to do business in the region, still there is a lot of good advantage to have a good environment for international arbitration, friendly court to arbitration, because this is very important. And this is something we try to do now. You not often see a sitting judge going outside and attending conferences and speak about his practice and the court practice, but I think this is something we have to do going forward. We cannot sit in a closed door as a judges and not listening from the community, from the practitioner, taking back the feedback, what need to be done better to help the arbitration practice. I don't want to say too much because my colleague, they need to speak about that. And if there is any question later on, I'm very pleased to answer that. Appreciate it.
Thank you so much, Justice Shamlan. And yes, I think we should offer some maybe alternative for parties who are doing such a huge scale of business between the UAE and Israel. Like, for example, arbitration institutions such as the IICA, such as DIAC. We're in touch with Bahrain Arbitration Center and even the Saudi Arbitration Center. And we're even thinking about a regional arbitration center for this. Khalid is as I said, the president of the Moroccan-Israel Business Association. He is the general secretary of the Marrakesh Bar, and he is the vice president, the vice mayor of Marrakesh for the last 30 years. And please, Khalid, if you can tell us about Morocco, many facts that we don't know about legal system and the connection with Israel.
Thank you. Good morning, everybody here. I want just to share with you, because I read a lot of things, a lot of speech, but I will change everything. I will speak by my heart. I will share with you my experience. I come here first time to Israel 4 years ago. And when I come to airport, they ask me if you want to stamp police immigration stamp, or you want just I give you some paper and you can enter, no problem. Before we take visa from Paris, I say to them, no, I want that you stamp in my passport. I am proud. It's honor to stamp. The future is this relation between Morocco and Israel, between Arab world and Israel. From this time, I used to come, but I feel here like I come home. I am not here as foreigner or as tourist. If we see in this place, in this meeting, we will find a lot of Israeli origin from Morocco. That is the difference between Morocco and other countries, even with agreements. Agreement with Morocco, it's very, very different, because it's not just agreement, but we have blood. We have 2,000 euros that we share. We have heritage that we share. We have a lot of things that we share. So it is different. When Israeli come to Morocco, they feel home. When Moroccan come to Israel, they feel home. So for us, it's not just a dream, like Martin Luther King say, it's dream. For us, it's dream, it's history, it's heritage, and we are here, and we will do everything to promote relation between Morocco and Israel. Through Abraham Accord, or through our heritage, through our education. So for us, it's very, very important, this meeting. It's historic meeting. It's something that we will ask our children to return to see what happened here in Israel. What happened to see these people, smart, who work hard, who are for their economic, for their industry, for their agriculture, everything. You cannot have development if we don't have Jewish population, Jewish heritage. Jewish heritage, it's mean progress everywhere. So for us, for Moroccan, that we share 2,000 years with them, we know, we study together, we work together, we do agriculture together, we do everything together. So for us, with this accord, it's very good, but we have the past of the accord. We had 2,000 years before. What we can do with this accord, Abraham Accord, we can do a lot of things. But until now, after 2 years, we don't do, I cannot say nothing, but we do really 10% or 4% that we have to do, we have to work for. We need to say that we need to work not just as government. We can work as civil society, we can work as university, we can work as chamber of business, we can work as college, we can work as professional, and we can work as citizen. We have to work, we have to move. We have to move. I want to return back to this incident that happened in Africa, in this Union of Africa. Why Algeria tried to put Israel out? Why? Why they are always against Israel like Iran? Why they didn't want that Israel involved in economy of Africa? It's very important to have this answer, because Israel can make value, can make be locomotive of all Africa. If Israel work with Morocco, Israel will push Africa up, will help in agriculture, in economy, in high technology, in everything. That's why it's very important. When we speak about arbitrage or international arbitrage, we need also to speak about Africa. It's very important, not just Moyen-Orient, it's good, but Africa is the future. A lot of things to do in Africa, a lot of human resource in Africa. If you don't have Africa, you don't have nothing in the future. That's why in Africa you find China, you find America, you find oil person that have very important vision. Russian and oil. Oil are interested in Africa. Why Algeria say no to Israel in Africa? Because they know if Israel is there with friends like Morocco, like Ethiopia, like others, will be very important for Africa. I want to say about arbitration. We speak about arbitration. It's very important for economics, for promotion of investment, for everything. A lot of investors coming from Israel to Morocco, they say we want to invest, but really we don't trust justice, we don't trust this, we don't trust it. We need guarantees about our investment. How we can invest in Morocco and we don't have to follow cost procedure and long procedure in justice. How we can? You have arbitrage because you didn't know anything about legal institution in Morocco. Sure, we have arbitrage. We have mediation. we have oil guarantees for investor in Morocco. And it is very, very important to know, and our mission, our job to show this. And we are here to say that we have a law, that we try now, when we try now to change a lot of things, to close tribunal and to open more and more center for arbitrage. We try to close prison and find other solutions like bracelet and other things. Morocco is very modern now. Morocco have changed now. Morocco now with Israel will be locomotive of oil development in Africa. That's why we are here to say that we have this institution of arbitrage, that we are here to find experts in your meeting, that we can work together. It's not just in this meeting, we can be open meeting, we can work by distance, we can change our expertise about this, and I hope that you can come to Morocco. You can come to Dakhla, exactly. Will be next meeting in Dakhla, in the south of Morocco.
Inshallah.
Okay, I just even less than 1 minute. Why Dakhla? I used to say Dakhla will be the next Singapore of Africa. I want to say why. We have everything. We have petrol, we have gas, we have energy, we have agriculture, we have tourism, we have everything. Just this region. I don't want to speak about the region of Gulmim, Wadnoun. I want to speak about region about Al-Ayun and Saqia. In the south of Morocco, I invite you to come to see the potential and to see why not to have this chamber, Israeli chamber, in Dakhla. Uda will be open in Dakhla, and we hope that we will meet together in this time. Thank you very much.
Thank you. Thank you so much, Khalid. And talking about Morocco as a bridge to Africa, there is one more state in Abraham Accords from Africa, which is Sudan, which might be a bridge to Africa as well. And Stu Newberger is a senior partner with international law firm of Crowell and Mooring. His practice centers on handling complex international disputes. Stu has over 30 years of first chair experience as an advocate in the US courts, as well as international arbitration venues around the world, including ICSID, ICC, LCIA, AAA, and many more. And Stu, you were a person who was involved in the legal proceeding in Sudan, which led to the integration of Sudan in with the framework of Abraham Accords. And please, because of the time is so short, if you may just share with us the process of what happened in this for these agreements, and what is the potential between Israel and Sudan?
Thank you, Menashe, and also to Shai for inviting my firm to participate, and a number of my colleagues who are here from our London offices, Los Angeles, Washington, and interestingly, we have an office in Doha, Qatar, and inshallah, someday Qatar will join the Abraham Accords. Let me, first of all, and thank this very distinguished panel for letting me participate. My approach here is very different. My path to this panel is very different. Although I've been to the Emirates and I've been to Morocco and obviously come to Israel quite a bit. On August 7, 1998, Al-Qaeda carried out 2 terrible terrorist attacks on the American embassies in East Africa, one in Nairobi, Kenya, and one in Dar es Salaam, Tanzania. The one in Nairobi was particularly gruesome. It was carried out and killed not only many Americans, injured many Americans who worked at the embassy, but many Kenyans who worked at the embassy. And hundreds of Kenyans in Nairobi, and thousands were injured. Thousands. It's a terrible, devastating attack. What does it have to do with Sudan? Well, Osama bin Laden and Al-Qaeda were based in Khartoum, Sudan, for many years. And the former president, and I'm glad to say the former president of Sudan, General Bashir, really created a haven for terror that was not only directed against the United States, but was directed against Israel, was directed against the West. It was actually directed against many other Arab nations, including the Saudis and many in the Gulf and in Africa. So how did I get involved in this? Why did I get involved? We have in the United States something called the Foreign Sovereign Immunities Act. And if an American or someone who worked for the American government was killed or injured in a terrorist attack, and they could have proved by evidence that a country that was on the list of what we call the state sponsors of terror, Iran was obviously still on that list, Libya was on this list, we worked on many Libya cases, but Sudan was on this list. And because Sudan was on this list and provided a safe haven and support for al-Qaeda and these attacks on the American embassies in East Africa, we were able to file a lawsuit against the government of Sudan in the federal courts in Washington. And my law firm represented all the Americans who were killed, their estates and their families, in those attacks. And many other law firms represented other victims of that attack. We were in the courts for many years. Sudan eventually defended itself in those cases. Indeed, a very distinguished international firm, White & Case, represented Sudan in that case. The case went to trial in the trial court, the federal court. It was upheld. We got a very large judgment against Sudan. It was upheld by the Court of Appeals for the D.C. Circuit. It was upheld by the United States Supreme Court. And once those judgments became final, we were very involved in working both with the U.S. government and the Sudanese government and the Israeli government and the Emirates government in helping to create a bilateral settlement between the United States and Sudan, which accomplished three very important things, one of which is very relevant for this conversation. First, the settlement provided for a very generous compensation package for our clients and other victims, both American and non-American. Those who worked at the embassies also were included in the compensation. Very important. This was not just for Americans. Number two, because of the settlement, Sudan was removed by the United States from the list of state sponsors of terror. Now, that's just not a label, a badge they get. It has very serious regulatory and sanctions consequences. And Sudan was desperate to get off that list. Third, and the most important for today, was as part of that process in the year 2000, the United States and Israel and the Emirates and others, including the Saudis, were very involved in working with Sudan to have them sort of rejoin the family of Arab nations through the Arab League and to talk to the Israelis. In fact, Prime Minister Netanyahu, in a prior time in office, met with the general who took over from Bashir at a conference, I think it was in Uganda, and they publicized it. It was a big news event. And why is this so significant? Well, in contrast to the Emirates, in contrast to Morocco and Bahrain, which were not, as we call them, confrontation states with Israel. They didn't fight wars with Israel over the years. In fact, there were many quiet relationships between these countries and Israel and the West. Sudan, though, was a confrontation state. As many of you may recall, in August of 1967, Khartoum was the scene of the Arab League meeting, the famous three no's. No negotiations with Israel, no recognition of Israel, no peace treaties with Israel. The famous three no's. And it became a terrorist state, not just a confrontation state, a terrorist state. Indeed, as recently as 2012, fairly recently, the Israeli Air Force was bombing Iranian shipments of weapons and missiles that were coming through Khartoum to provide weapons to Hamas in the Gaza Strip, which, by the way, not only was directed at Israel, but against Egypt and Jordan and the Saudis, as well as the Israelis. Now, once all of these things came together, the legal threat that we had against them in Washington, the military and diplomatic pressure that was put on them by many members of the Arab League and Israel and the West, Sudan eventually got rid of Bashir, who's in prison, by the way, in Khartoum, and is no longer in power. And Sudan is now taking steps towards diplomatic recognition of Israel. In fact, the foreign minister of Israel was in Khartoum, 3-4 weeks ago, trying to take the next steps on this path. Now, Sudan is way behind the Emirates and Morocco and Bahrain in developing its relations, commercial and legal, with Israel. But that's happening now, publicly and formally. And there are opportunities that are going to come up, I think, that will benefit both the Sudanese and Israel and the region. Why? Sudan does not have oil and gas. They are not an energy producer. They are an agricultural state. They're a huge, huge country. If you look at the map of Sudan, it's a humongous country. It is also geographically located in a very critical part of the world and of Africa. They are on the Red Sea. They are directly across from Saudi Arabia. They have the border with Egypt, and they have a history with Egypt historically. Also, people forget, Sudan was a British mandate territory until 1956, just like Israel was until 1948. There's a lot of things that are in common. But Sudan has a lot of problems. The country was broken in half mostly under Western pressure, so that you basically now have the regular Sudan, North Sudan, which is basically a predominantly Muslim Arab country, and then South Sudan is a predominantly African Christian country. And they have developed a lot of problems there too. So much for nation building. But what is the potential for the future from that? Because that's really what Menashe wanted me to talk about. In summary, Sudan, because it's predominantly an agricultural country, but still very poor and very backward in its technology and its economy, desperately needs the type of technology that Israel can offer to them, particularly in agriculture, high tech, in water resource management, of which Israel has the leading science and technology in the world, and in how to develop that for trade. Sudan's biggest trade partners now are Saudi Arabia. Saudi Arabia buys a lot of its food and livestock from Sudan. It's just across the Red Sea. It's a very short boat ride. But if they can improve how they grow their crops, how they raise their cattle and their sheep and lamb, if they can do that, and with Israeli technology, they know that's going to help them, they can increase not only the food available to their own people, who desperately need it, but they can become a very major exporter of high-end agriculture and food products in Africa, in the Middle East, in the Gulf, and throughout the region. This would benefit Sudan. This would benefit the fellow members of the Arab League. It would benefit Israel, which can really show them the way for the technology and the type of work that can give them a modern agricultural system. And that, of course, will improve everything else in the country. It will stabilize the country, because when you feed your people, when you have stability, you don't need terrorists there. You don't need to host Osama bin Laden. You don't need to have Iran shipping missiles up to Hamas in Gaza. And that's really the potential that we see for those of us who kind of know the region and know what the benefits are and the options. And we're very hopeful. And maybe in a couple of years, we'll have someone from the Sudanese government join us at one of these panels to tell us how they've now improved not just their relations with Israel and the other Arab countries and African countries, but how they've improved themselves and made their own country have the potential to be a very positive force in Africa and the region. And let's see, that's an inshallah with the capital I. So I hope that's kind of a way to help everybody understand that Sudan's come to this in a very different way than our friends from the Emirates and Morocco and Bahrain. But somehow, even a former enemy of Israel and, frankly, of the Arab world itself has turned around. And that's a remarkable story that we can all be very hopeful will produce positive things for the region and the world. Thank you, Menashe.
Thank you so much, Stu.